Federalism is the third big pocket area of issues within constitutional law. Federalism is the relationship between the federal government and the states' governments within a federal system. This is fairly intimidating material, especially to foreign candidates for admission to the bar exam in the United States of America. But really, this material is not terribly difficult, and the part of this material which is most commonly tested is very important and completely understandable. So, as we get into a consideration of federalism, the first area that the National Conference of Bar Examiners puts us on alert that we need to know about is intergovernmental immunities. This material is very seldom tested, and it's not terribly complicated. Realize that the federal government has got certain immunity from state law, and the state governments have a degree of immunity from federal law. With regard to federal immunity from state law, we see that suits against the federal government typically are prohibited, although we do allow the states to sue members of the government in their official capacity. We see that the states don't have any power directly to regulate the federal government, and we see that the states are not entitled to tax the federal government. But this taxing issue is one where there's a fair amount of fine print, and it is fairly commonly tested. Let's suppose for a moment that a state has got a taxing regime in place in which all office buildings of a certain size within the state are subject to a tax. Question: are federal buildings that are leased within this state subject to that tax, or is the federal government immune from the tax? Answer: the federal government must pay that tax so long as the state is not trying to discriminate against the federal government. So if the feds are expected to pay the same tax on an office building that a private company would have to pay, that tax is legal. If the state tries to tax the federal government triple the rate or some other different higher rate than the local rate to businesses, that would be considered invalid, and the federal government would be immune from paying that higher tax. Next, we consider very briefly state immunity from federal law. Again, there is immunity from suit. There is a degree of immunity from regulation. And with regard to taxes, we see that the federal government has the power to tax and to regulate the instrumentalities and employees of state government, again, so long as there is no discrimination. So, state employees are subject to federal income tax, etc. So, intergovernmental immunities are not heavily tested, and they're not terribly complicated. In practice, you may see a few questions if you do hundreds of multi-state questions on constitutional law, and you can annotate your outline with one or two further details if you really feel you need to. But when we get to the authority that's reserved to the states, this is the important part of the material about federalism. States' rights. What powers have the states got, and to what extent can a state exercise power without running afoul of federalism? So, the most commonly tested area of law within this area of federalism is the state's power over commerce. And also, probably it would be better to characterize this as federalism's greatest limitation on the state's exercise of power would be based on the commerce power. Now, when we considered Congress's authority, we pretty much led off with the power to regulate interstate commerce. That's an express right in the Constitution that the Congress has got. So when we consider Commerce Clause issues relating to the states, what we are really concerned about here is the so-called dormant Commerce Clause, which allows the states a fair amount of latitude with regard to regulating commerce. I'll give you a couple of details about that below. We also see that there are limitations on the state's power to tax, and these limitations deal with foreign commerce, interstate commerce, and we see due process and equal protection issues related to taxation. These are rarely tested, and it's much better to study this material with an actual hypothetical or a multi-state question in front of you. I don't have a great deal to say about this up front. The 10th Amendment reserves powers to the states that are not expressly granted to the federal government. where the federal government tries to interfere with a state's power to regulate within the state can allege a 10th Amendment violation. And the most on-point issue currently with regard to the 10th Amendment involves the federal government's efforts to disrupt and undermine California's medical marijuana program. Apparently, the federal government has been targeting for prosecution the doctors and patients and clinics that are most in compliance with California's medical marijuana law. So the federal government is going after the sickest patients and the most honest doctors and clinics, as opposed to going after shadier operations that look like recreational drug use disguised as medicine. So, in California, the city of Santa Cruz and a few other plaintiffs have sued the federal government, alleging, among other things, a 10th Amendment violation. And the plaintiffs in that case have recently prevailed in a summary judgment motion. So the state certainly has actually stated a theory of liability under the 10th Amendment that's valid. Now, I don't think it's very likely that you'll see a medical marijuana question on the bar exam, although it's certainly possible. But by analogy, we certainly could imagine a scenario on an essay or on multi-state questions where the state has set up some legislative device and the federal government, for its own reasons, chooses to target that state regulatory scheme for interference. To the extent the federal government is treading where it doesn't belong, a 10th Amendment violation can be alleged. We see that there are also some specific limitations on state power, and again, those are best discovered through practice. That material is very seldom tested. Now, up front, earlier in this presentation, I explained that the states have got the primary police power. The executive is the chief executive in the federal government. The president is responsible for law enforcement. Congress is not. But in the states, the power over policing, taking care of the health, safety, and general welfare of the population, is a core source of states' power. Now, as we consider interstate commerce in just a little bit more depth, the basic idea is that the state is not allowed to discriminate among the states, and the state is not allowed to unduly burden interstate commerce. And the only big exception to this is where the state is a market participant. Where the state is a market participant, the state is allowed to compete more aggressively than in situations where the state is not a market participant. And here we often see questions on the bar exam and on law school exams dealing with a state wishing to have additional regulations for traffic safety. Question, does this violate the commerce power? Answer, it depends on the facts, but probably not. So we see that where the state is a market participant, for example, dealing with landfill ordinances, where the state gives preference to its own local waste as opposed to waste from other states, to the extent the landfills are operated by the state in question, that power to discriminate is greater than it would be otherwise. Where the state is a market participant, they've got more power to discriminate against out-of-state commerce than they would otherwise. So, finally, in this area, we consider the national power to override or to extend the authority of the states. Those are opposites. The federal government sometimes can override state regulations and sometimes can grant to the states a greater power to regulate than they had before. Remember that the Supremacy Clause is where Congress's legislative authority trumps state authority. But remember, the Supremacy Clause is not a source of congressional power. Rather, it is a way to interpret statutes to determine whether or not the federal government's statute ought to trump local law. We see that preemption is another limitation on state authority, and we see that Congress has the power to authorize actions on the part of the state that otherwise wouldn't be legal. So, suppose the federal government chooses to extend to the states powers that otherwise would violate the Commerce Clause. Can Congress give the states authority over commerce that they wouldn't have otherwise? Answer, yes they can, because the federal government has got the power generally to extend the state's authority beyond its natural boundaries under the Constitution. So finally, we turn to relations among the states. This is a tiny little area that sometimes is not tested at all, but still it's worth being aware of. We consider here the laws dealing with interstate compacts and the full faith and credit clause. Now, the full faith and credit clause is probably the most important of these tiny little areas, because here each state has got the obligation to afford full faith and credit to the decisions of other states. So, if there's a lawsuit in State A and one of the parties is in State B, State B's court has to acknowledge and enforce the State A verdict to the extent that that's necessary in State B. And we can certainly imagine full faith and credit arguments dealing with gay marriage. So California or Massachusetts has a valid, legal, same-sex marriage. That marriage becomes domiciled in a state that does not recognize same-sex marriage. Question, does the full faith and credit clause require a state that doesn't recognize gay marriage to, in fact, recognize a marriage from one of the states that allows gay marriage? Answer, that's actually a good question, and it hasn't yet been conclusively answered. That would be a fairly explosive Supreme Court case, and it might be something that you need to think about in advance. That's a question that would be, I think, fairly ripe for testing. It's also a question that, at the time of the recording of this video, there isn't a determined or a definite constitutional answer. So that wraps up a consideration of federalism.